Good morning. Happy Tuesday. Document 114 is out, and surprise, surprise, the judge didn't comment, didn't do anything except stamp denied on the motion for reconsideration. Motions for reconsideration are a very difficult proposition to do. If you're going to do it, you have to put a lot of care into it. The correct way, the way I would have done it, because I'm an attorney, not DeCastro, is I would have started at the beginning and I would have very laboriously laid out my entire argument. Section 1, the cases that the court cited are inapposite. They don't apply to the particular fact pattern that we have because there were motions. There were motions that were filed seeking leave to late file. Step 1, go through each one and explain why. This one, the court clearly lays out in the fact pattern that there was a motion. This one, the court clearly lays out in the fact pattern that there's a motion. In this one, the court does not clearly lay it out, but the court relies on the other previous two that clearly laid out that there was a motion filed. So you deal with those three. These three did not apply. The basis of the court's decision, the cases the court relied on, don't apply. Step number 2, Lujan. Lujan says that you have to have a motion. Lujan says specifically you have to have a motion. Cite the specific language, not a block text, but the specific language in Lujan that says you have to have a motion. Lujan further says that the motion has to be clear. It has to be unequivocally a motion. Cite the language in the footnote 5 that says that. It can't just be the court construing an affidavit or other pleading as being a motion. Cite the language, the specific sentence, don't block text it. Courts blow past block text. It's not a good practice to block text, at least not important information. So it can't be an affidavit that's treated as a motion. It has to be a specific motion. Cite the language. In Lujan, the Supreme Court said that the district court had to treat it as not being a motion because it was just a few lines at the bottom of an affidavit. Cite that specific language. Because of that, the court needed a motion to proceed. Cite the language in Lujan. There was no motion. It was an opposition to, first of all, the initial was an opposition. And then Wish's response was not a motion. Lay it out. Based on the foregoing, the court lacked, don't argue excusable neglect. You muddy the fucking water. Based on the foregoing, the court lacked the discretion to determine whether or not she could make the filing. The court only had the discretion if there was a motion that was clearly a motion pending, to which I could have filed an opposition to. There was none, based on Lujan. Therefore, so you really have to lay it out in painstaking detail. And I'm not just saying that it would be, think about me having made like 3 fairly reasonable length videos on it. Think about that, to cover really all the full aspects of it. You would have to get all of that into a pleading. You'd have to be succinct enough that you don't bore the judge, but you'd have to start strong. There's a format they teach you in law school. It's a CRAC. Sometimes they want to do IRAC, but IRAC is not. IRAC, it would be like if a client says, "Can I do this?" Then you do an IRAC. But in a pleading, you do a CRAC, and CRAC stands for conclusion, rule, analysis, conclusion. So the conclusion would be, and you don't want to make these too broad, the conclusion would be that the 3 cases cited are inapposite to the situation at hand. The rule is that 6B, 1B, blah, right? The analysis in case number 1, the moving party filed a motion. Here's the language from case 1 that says they filed the motion. In case 2, there was a moving party who filed 2 motions. Cite the language from the original case that said that the moving party filed a motion, 2 motions. Case 3, the court was unclear as to whether there was a moving party. They did use the excusable neglect language that is in 6B1B that requires a motion, but the supporting cases that court used motions. Cite the language. Conclusion. The cases are inapposite because in this case, there was no motion filed. Boom. So CRAC. What Chili is doing is Chili is being very sloppy, and he essentially just threw out Lujan for the second time. He says I had it in my original motion. That's telling the court right off the bat. If you lead with, as I already previously stated, then the court's going to be like, well, you're just rehashing the same argument. I've already dealt with it. I've already denied it. So you have to start off with the court, bop, 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 bop. You have to lay it out, painstaking detail. Chili didn't do that. Chili failed. That doesn't mean the court was right. And Chili still has an issue for either an extraordinary writ or an appeal at the end. Now, yes, I am aware that Chili has filed a lawsuit against Kate in California Superior Court, somewhere in the Los Angeles area. I don't really care which court it was filed in. Doesn't matter to me. Do not care. I have not done any analysis of it because I haven't seen the actual pleadings. It was pointed out to me. I forgot that you could serve out of state according to California Code of Civil Procedure. You can serve out of state defendants via registered mail, return receipt requested, or certified mail, return receipt requested. I forget the actual language. But basically, as long as it actually gets to them and they sign for receipt of it, that is sufficient for service. So it should be fairly easy for Chili to serve Kate. But where he goes from there is not going to be too much fun. Or he could also do by personal service, etc. Are you giving him hints on how to serve her? No. I mean, this was openly discussed in my Discord server, so I'm assuming that he's watching my Discord server, so I'm assuming that he already knows these things. I'm just making a video on it because other people might want to know. Are you helping him, John? Are you being an OG troll or whatever? No, I'm giving the same analysis that I would give for Kate. Just because I don't particularly like him doesn't mean I'm going to lie, doesn't mean I'm going to lead him astray. I'm not going to lead anybody astray if I could possibly help it. Because it's not just going to be Chili that's going to be watching these videos and thinking about how they can do things in their own cases. Other people are going to come along, people I don't have any personal disagreements with, and they're going to want to use these or the insights available. I try to make these fairly broad so that you can apply them to multiple situations. And that's another reason why I don't really like this opinion by the court and why I think Chili should appeal it. It's not because of how it affects Chili, but how it's going to affect other people who aren't Chili, people who might be good, honest, hardworking, upstanding citizens who have an honest issue with a late filing. And I mean, that's how Lujan made it as far as it did. That's how other cases have made it as far as it did, is because people who maybe you don't have a beef with have the same issue. And if the court's doing this to Chili, the court's going to do this to other people. And so it needs to be rectified. We need to have clarity. Apparently, it's not clear enough for this district court to get it through her head that Lujan says no. And so I think it needs to be clarified. And just because it happens to benefit Chili, I mean, it's also going to benefit everybody else. I'm not in this. I'm not going to cut off my nose to spite my face because I don't happen to like the guy. I mean, I don't actively hate him or anything like that. We have to have a consistent set of laws that apply to everybody equally, including people like Earl David Warden, including you. You, dear listener, you would want the laws to be applied fairly and equally to you. You would want the court to follow procedure for you. So, yes, the court needs to do that for Chili too. The court needs to do it for the people you don't like just as much as the court needs to do it for the people you do like. Anyway, that's it for today. Thanks for watching. Have a great day.